Okay, everyone. This is Chai Feldblum, and it's 2:51. So I'm always a big believer in trying to start on time, and I know we will have to end on time in terms of the conference. Well, that was quite a panel that we just heard from. It was really amazing. I was talking to Rilla before that she recommended me to Central Synagogue to be the lawyer doing the investigation. So I was the Jewish lawyer that Nancy was referring to. And it was just remarkable what Central Synagogue did. And I do believe that what it demonstrated as a model is made a difference for all the other organizations that came afterwards. So we have a short period of time here. So I'm going to speak for a relatively short period of time. I am putting my watch on for 15 minutes because we're a small group and you are all in positions of leadership. And so I want this to be an opportunity for you to have a conversation with me, but also with each other. So I'm going to make about 4 points, putting the law in the context of what you've been hearing. And then I will open it up, and I'll open it up to questions, obviously, if you have questions, but you don't have to try to figure out how to frame your comment into a question. Okay, it can also be a comment. Like, oh, you said that really resonates for me because we're going to learn from each other in that way. Okay, so like I said, 4 points to set the context. In the context of what's law got to do with it. So first, what you want to achieve in your workplaces, vis-a-vis employees, and in your organizations, right, where you're going to have people who are not employees, people participating in events or congregants if you're a synagogue. What you want to achieve is to create and maintain a culture in which everyone is treated with dignity and respect, including not being subjected to harassment on a protected basis, such as sex. That's what you want, and you have heard so much in the past, day and a half about the importance of culture. Now, law on its own is not going to get you to that workplace culture. You'll have to do a lot more, and you've heard a lot about that. And when I worked for 2 years at Morgan Lewis and helped expand the DEI practice, including anti-harassment practice, we use both law and lots of other mechanisms for changing culture. But it is helpful to be aware of the laws that apply and to understand how law can actually be leveraged to get you to that workplace culture place. Second point. Federal law primarily prohibits harassment and other forms of discrimination in employment. Right? These federal laws cover a range of categories: sex, including LGBTQ status, that's protected right now under federal law in employment; race, religion, national origin, age, and disability. And the law holds an employer liable for harassment that occurs in the workplace. And if harassment is found, the employer can be required to take steps to stop the harassment, remedy the harassment. You might have reinstatement of someone, and also to remedy the harm caused by the harassment, including through paying damages. There is no federal law that prohibits sex discrimination in a range of organizations like those represented here with regard to people who come into contact with the organization in roles other than employees. Ain't no federal law, but there are often state or local laws prohibiting discrimination, including harassment in some situations. So the second point is, what are the laws? What's the coverage? Third point, under federal employment law, there is a high bar for what constitutes illegal harassment under the law. Okay, there is a lot of bad behavior that you're going to want to nip in the bud even before it rises to the level of illegal harassment. So it's important for you to understand what that definition of illegal harassment is, not only so that you know when you have legal exposure, legal risk exposure, but also because you don't want that defining the behavior that you stop. You want to stop behavior before it reaches the high bar of what would be illegal harassment. So what is that high bar? Under federal employment law, with regard to harassment based on sex, the unwelcome behavior based on sex has to be either severe or pervasive. Either severe or pervasive. So severe means severe. It could be quid pro quo. You must sleep with me to keep your job. It might be unwanted sexual touching, clearly sexual touching. Now, if the behavior isn't severe, it can still be illegal. But that unwelcome behavior has to happen many times. The behavior must be persistent, hence the word pervasive. Because if the behavior is pervasive, then the courts consider that as rising to the level of creating a hostile work environment. And that's that legal term of hostile work environment. As I said, you do not want to wait until the behavior reaches that level. You want to stop that behavior, nip it in the bud. You want a culture in which such behavior is simply not tolerated, even if it happens just once. You want it that if someone, touches someone in a way that, even if not overtly sexual, is clearly making the person uncomfortable or says something to the person, you want that person to feel safe to come forward, to tell you about it, and for there to be a process in which something happens quickly and effectively. And that leads me to my fourth and last point for setting the context for our discussion. Under the law, an employer must show that it took, quote, reasonable care to prevent and promptly respond to cases of harassment. So think about that. You have to show that you took reasonable care to prevent and promptly respond to cases of harassment. Now, in certain cases, the employer is just going to be directly liable, regardless of any of this. Like if it's a supervisor that took a tangible employment action against someone, like a really quid pro quo, then it doesn't matter how much reasonable care you took, or how well you responded, that you are liable like that. But if it's not that situation, it's not a tangible employment action, it's just that you've made the workplace really tough for that person to work in, then essentially this is what makes the employer get out of having to pay damages. So there are situations in which a court will find, yeah, that was harassment, that rose to the level of illegal harassment, but we are not going to hold the employer liable for damages because one, the employer had taken reasonable care to try to stop this from happening. And as soon as the employer found out about it, the employer took the necessary steps. And what I found when I was, advising clients, they would often feel like, oh, well, if I took effective steps when I was first told, that's it, I'm fine. And I said, no, you need to see what the workplace was like before this person brought a complaint. Had you put things into place that showed that you were taking reasonable care not to have this happen in the first place? Now, under the current case law, at least to date, I think courts might be getting a little stricter, but, well, at least some courts. But under the current case law, what does it mean to take reasonable care? Essentially, you have to have a policy that prohibits such behavior. You have to have procedures in place, reporting procedures and investigations. And you have to have training. That's really the components. And for years, employers could have really sort of not great policies, procedures, and training, and that was enough. But here's where I think you can leverage law to help you achieve the culture you want. Because you can choose and shape the type of policies and training that you will offer. Okay, so you can make this a really good policy, really good procedures, really good accountability, really good training. And it's all, quote unquote, required by the law. But taking a lot of what you've heard already, you put that into the training, right? You put into the training, hey, we want to hear from you if something is going wrong. You are doing us a favor if you tell us something right when it's starting. It's a lot easier to stop something the first week that is happening as opposed to 8 weeks later, as opposed to a year later. Don't wait till you get so upset that it then bursts out. We want you to come forward early. And lastly, I think the training that you offer can make a difference in this regard. So, number one, in terms of your policy, I'm a big believer in having a policy start with a respectful workplaces policy, making it clear that we expect that everyone will be treated with dignity and respect in the workplace, regardless of any protected characteristic. You're just treated with respect. And that's the behavior that you want. And in terms of a continuum of behavior in the workplace, it's respectful behavior that we want. Then we do not want uncivil behavior, even if it seems low level. We do not want bullying, which is essentially uncivil behavior in steroids. And then we don't want harassment, which is uncivil behavior or bullying or other actions that are taken because of someone's protected characteristic. So to me, the best training is training that covers that continuum of behavior and that situates harassment in the set of behaviors that we don't want. And then one last thing I will say about that training, and again, after doing the investigation for Central Synagogue, I have spent time helping them with their policies, which they've rolled out. They have one internally, for their folks, and they also have one that they put out generally to the synagogue. And it starts with respectful behavior, and then goes into anti-harassment. And the most important thing I feel in terms of respectful behavior training is that you teach people skills, because the best way to stop, especially the low-level uncivil behavior or even the low-level harassment, making a comment about how someone looks, or you look so sexy in that dress, to be able to train people how to give feedback, sort of in the moment or the day later, but how to give feedback to stop that behavior, to communicate that it's unwelcome, and then how to receive that feedback without feeling defensive. None of these things come easily to us as human beings, but there are tips, on how to do that. And then also for employees to give some skills and options for bystander intervention. That can be very complicated given the power dynamics. I always say to folks, do not feel you have to intervene. Certainly not in the moment if there's a significant power differential, but there are a lot of other ways to step up and help someone, even if you're not intervening in the moment. It might be going to them, finding out, was this really uncomfortable, and role playing what feedback might look like, or going to a supervisor. I mean, there are a number of bystander intervention pieces. And then for supervisors, the training adds two other pieces. It tells the supervisors how to take in a complaint, especially if harassment. Under the law, if a supervisor hears about a situation of harassment, the supervisor must report so the employer can take effective action. And so when people come and say, oh, I just want to tell you something, but will you keep it confidential? You have to train your supervisors how to be able to respond to say, depending on what you tell me, I may not be able to keep it confidential. And you have to understand why that's the rule in this workplace. And I hope you still trust me and trust the system. So teaching folks how to take in complaints, and then teaching supervisors how to coach an employee about when the complaint has been made. And again, if it's severe harassment, it's going in a different direction as opposed to coaching. But a lot of things that people say, oh, you look so sexy in that dress, you look so hot, and the guy doesn't think it's a big deal. You know, he's like, oh, my wife loves it when I say that. You know, like the training says, okay, great, go home, say it to your wife. Might need to say it more. But when you walk into this workplace, that's not okay. You know, that's not okay. But to learn how to coach an employee in a way that will work for that person. 45 seconds before 15 minutes. So I am going to stop now. Please indulge me while I go on mute and blow my nose. The plus about Zoom is that even though I'm hoping a horrible cold because I am testing negative for COVID, but thankfully on Zoom I can do this. So let me stop and take some comments and questions. I know that people have things to say, so I'm not going to be worried about waiting. Laura.
Hi. Thank you so much, Chai. This is really helpful. Can you say something about oh God, I just lost the term, but can you say something about sort of, if we go with the case that we just heard about something that happened a really long time ago, and the institution is a very different place now, and maybe some of these procedures are in place now, but they weren't 30, 40 years ago. What is the liability of the institution now? Yes, statute of limitations. That's the term. What's the statute? Yes. Is there a statute of limitations? And what is the liability of the institution now?
Yeah. So here's the thing. The institution, the synagogue, is not liable if it's been essentially for an employment situation. It's essentially 1 year. You have to bring that complaint and you have to bring it to the EEOC, the Equal Employment Opportunity Commission, first. That's the federal agency that was set up by Title VII of the Civil Rights Act in 1964 to take in charges of employment discrimination. So it's 1 year. So I will tell you, when I got that call from Angela and Jeremy, who's the president, and Marsha Kaban, and they said they wanted to investigate what had happened 30 years ago, I did say, okay, you know, you have no legal liability. And they were very clear about that. That's right. But we have an ethical, we have a Jewish responsibility. I did also say, because I did look at their policy, and of course it was better than it was before, but it still, you know, could get a refresh, which is what we did for them. But really the big difference is the leadership from the top, because you can have the best policy ever, but if people still feel afraid of coming forward, that's not going to happen. So, and you know, and they're so lucky that they have Angela. You know, I mean, it's just pretty amazing. Now, there was some potential legal liability actually for the synagogue with regard to the woman who was a minor when the action started, because New York, because of the Boy Scouts cases, had opened up and allowed cases to be brought. So like when we started, the woman potentially could have brought a case like up until August, but you know, I think it would have been sort of tough. And for her, I know really had no particular interest in going public. I mean, she had brought it to CCAR 20 years before. She had watched Zimmerman get basically suspended for 2 years, and it ended up being 3. But as Angela said, with sort of the narrative that maybe it was adultery, you know, as opposed to what it was. And it's just sort of happenstance that Nancy was friends with her. And when Nancy decided to come forward, she reached out to this woman whose name is not public and said, come forward. And that was not an easy thing for that woman to do, but I think it has it has helped with the healing that was long overdue. Okay, so Ariel, so my eyesight is really bad, including with my, so either Ariel, if you want to read the question, or Gula, if you want to read the question from the quote, from the chat, you can start. Is there best practice?
Sure. So is there best practice around how often training should be offered, or is there a legal standard? Ariel's mic
and
is-
apologies for the camera. Okay. So in New York, in California, there are a bunch of states that now require the training, sexual harassment training, to be annual. The other thing these states require is that in the policy, you actually lay out the legal definition of sexual harassment. As I said, I find that somewhat problematic when I write policies for folks. I put that definition in, but I put it in an appendix. You also need to say where to file charges. So that's annual for some states. Basically, I think you want to be able to do it that when someone onboards, sort of within the first, 3-4 months, if possible, to get them the training. And then I think annual training is a good idea, so long as people feel that training is worth it. It's so frustrating when this is such an important issue and the leadership cares, and then they're doing some online computer training. Now, New York City's online training is actually better than some other training I've seen, but the best approach is in person. But I've been doing some of this Respectful Workplaces training by Zoom, and it is doable, And so again, especially if you do the training and you record it, then when someone onboards, you can say, you have to watch this training. And it's basically 3 hours. So it's like 1 hour, this Respectful Workplaces training, 1 hour foundational info, and then 2 hours, some of the skills building. And then they can watch it on their own time, but just within the first, few weeks. Oh, that's encouraging people. 5 minutes left. Great. Okay, correct. Okay, let's get one more question or comment.
I see Marla has her hand raised.
Yep.
Hi, thanks. I have actually a couple of questions. The first purely legal question. What are the legal risks of an organization like Central Synagogue is religious organizations? There's some protections, but of doing a public investigation and a public report, which is outside of the framework of a legal court of law, and naming individuals. Are there legal ramifications in terms of slander or potentially restraint of trade or other kinds of arguments that put the institution at risk for taking those steps? And I'll hold my second question until after you respond to this one.
And always in these things, one has to say, and this is not technical legal advice, no client relationship. Yes, someone can bring a case for defamation, but you do not have a valid case of defamation if what is said is true. So someone who brings a claim of defamation, everything is going to come out. And that's not necessarily smart, like Johnny Depp, right? I've not really followed it, but I do a little bit on the headlines. He I guess, decided it was worth it. But especially if someone knows.
Well, and apparently it was in his case.
And it was, exactly, So, but in any event, but if you have found that someone engaged in harassment and severe enough harassment that you are going to be public about it, you have strong enough evidence. Like I can tell you, Morgan Lewis, the firm I was with, also did the HUC investigation. I didn't because I was advising Women's Rabbinical Network at that point, Mary Zabor. They mentioned a few people. That's because they had very strong evidence. There were other people they didn't mention. And Central Synagogue, in the letter they just sent, we actually investigated another rabbi, but it just wasn't strong enough to put the name out there. So that's that. They can sue, but at their risk.
So my other question is a little bit different and perhaps less in the legal framework of employment, but I think it's probably true for many organizations like mine that we work with a lot of lay leaders, and where there are issues, it can often be, a lay leader harassing a staff member. Usually doesn't go the other way, but what kind of, I assume there are sample policies having to do with lay leadership, but are there any legal aspects to that dynamic?
Yes, because an employer is responsible for protecting its employees from harassment, not just from fellow employees or supervisors, but from third parties. Okay, so if a lay leader is harassing a synagogue employee or an organizational employee, the employer must stop that. Now, if a employee is harassing someone in the synagogue, unless there's a specific law, the synagogue is not legally responsible, but that's where you want the policy to make clear that this is not okay. But the legal responsibility goes only if it's an employee who's being harassed. And by the way, volunteers are not covered under employment law. Now, a lot of people have volunteers. Now, if they have an intern that's being paid, then you're covered. It's 3:18. Oh, you said we have time for one more question? I think we have time just to say goodbye to everyone and just say I was so happy to actually be able to do a small session with just a number of folks who are clearly going to be digging into this in their own organizations.